now a good time just for some general questions?
Go for it.
Excellent. A Section 810, can you just tell me some basic information, like how that gets started?
I'll transfer your call. Are you asking a bunch of criminal questions? Is that what you're trying to do?
I've heard this Section 810. I've been kind of led to believe that's like a peace bond. I was just wondering what the process is for a Section 810.
Oh, okay. Have you made an application?
Well, I'm just doing due diligence in order to get an idea of what that entails.
Okay, yeah, it's basically peace bond.
Okay, what is that? What is the first step of this peace bond?
If you are making an application against someone, so there is a process. But
Okay. So are you saying that the first step to an 810 application is the application itself?
Usually, or has it been reported to the police?
Are you asking me? Is that what you're saying?
Yes.
Well, no,
Yeah.
I'm trying to find out about it in order to know if that's something that is a service I could maybe potentially use. So I'm just trying to get information. Do you have any information as to the first step for a Section 810?
Let me find out for you.
Yeah, I appreciate the effort.
And, yeah.
I'll hold.
Hi there, thanks for holding.
I'm still here.
Yep. So basically, you just have to start by going to the police and providing the details there, and they will walk you through the process. We just deal with the applications in the courthouse, not the actual 810.
Okay, so do you have any, sorry, have I contacted the clerk of the court? Is this the right number?
And this is the Duncan Court Registry.
Okay, sorry, am I speaking with the clerk of the court?
No, you're speaking to the registry.
Registry, okay. Who has these procedural answers?
The police.
So who's in charge of procedure, the police or the court for the court hearings?
Well, it's dealt with Crown.
Okay, so the court and the police are both representing Crown. So is it Crown that you're trying to direct me to? Is that correct?
No, I mean, if you don't have anything in place, then you go to the police first. But if you have something in place with it, then you contact Crown.
Right. I hear what you're saying as a suggestion. I'm just trying to get a procedural understanding as to what it is this thing called 810 is before I decide on going to the police and beginning. I just don't want to waste anybody's time, right?
Right. So basically, it's an allegation, and the complainant is an intimate partner.
Okay, so would you say that could you just give me a little bit of an idea? Is the first thing that would come up on CSO would be an application, or what is the first official step?
No, it won't come up on CSO unless there has been something reported to the police, and there's been like an alleged allegation of that other party.
Okay, is that
and then
something?
it still has to go through Crown to set a date.
Okay, right. So, just a little bit of information from what online has told me. Not that I believe it all, but it seems like the first step is a sworn application, then a judicial review, then a summons is issued, and then appearance for reconnaissance. Is that sound correct?
Yeah, it sounds similar to the process.
Okay. And this sworn application, I'm trying to get an understanding. Is that something that comes up on the CSO? No. Okay. So then the judicial review, does that get posted on the CSO?
I'm not sure. I'm not familiar with the CSO. We're not part of it. It's just
So is the
services online, and
okay? So
it just offers information, and if they want any further information, I think there's documents that you can pay for if you're part of the party.
Okay, so if somebody had questions about CSO, who do they call? Is there another number, since they're kind of the ones holding the files that?
Did you call them up from the website?
I mean, I didn't know who to call. I guess we're first contact, so you're kind of guiding me. Thank you. The website actually says that there's as is and takes no liability, so I usually call because I'm not really sure what all that means, right?
Mm-hmm.
So yeah, if you don't have any answers, if you could just direct me to who I need to talk to, because maybe I'm in the wrong place.
Yeah, you can just go to the police department and go to their front desk and ask to speak to somebody higher up if they don't give you the right answers that you're looking for.
Okay, and what would I ask them?
About an 810.
Okay. And so the police are the ones that have the answers. So I just want to make sure that if I do that, you're saying that if they tell me otherwise, I need to let them know that I've done due diligence and that I was told that they do have the answers.
That's correct.
Okay. And have you ever had any questions about a Section 810? Is there any other place you can direct me besides the police? Is there any official access to information instead of just speaking to someone?
You can just look it up on the website.
Oh, well, I just mean, is there someone I can call? The website has a lot of disclaimers I don't understand.
I see. No.
So the police are...
you could ask a lawyer.
So a JC is not involved in the process, and the court's not involved? It's all just police?
Yes.
So the police enforce as well as process the 810.
That's correct.
Okay, so does that mean that the police issue their own warrants? They do.
Well, it depends on if it's her.
And it doesn't need any judicial review, no sworn application, or a reconnaissance?
There is a process. So I just suggest you have talked to there's lawyers.
Oh no! I don't necessarily need to pretend that I'm involved in it. I'm just doing due diligence. So I'm just trying to figure out who knows. It sounds like the police might be an option, but they're not the ones that actually they swear it to the court, and the court's the one that posts it at the registry. So that's why I thought I'd call the courts. Are you saying that it's not related to do with the courts, and the courts just do what the police say?
It goes through Crown. It goes through Crown.
I'm just looking for the resource that you're quoting there.
Okay.
It shows a failure to appear on
appreciate the
August
effort.
8th. There was no summons issued.
We have a deal with the court registry.
I like this car. How do you turn it
Failure
off?
to
If I
appear
go
on
to the
August
road, it's
8th.
going up
There
and
was
down,
no
that's pretty
summons
good.
issued.
What is your name? The record moved anyway.
I see what's going on here. Oh, she knows. This is the picture we went and sat down.
Court day, right? Wait till you see this. They call it a court of law, but it plays like a matinee. Judge with a pencil crown, jury reading off scripts, bailiff and bells. It's a clown show. Pure theater of knowledge. Everyone's got their part. Me? I guess I'm the fool they cast to remind the crowd it's all make-believe. Curtains coming down, but the
Criminal
bookkeeper...
desk, how can I help you?
Oh, is this somebody new?
It is. How can I help you?
Oh, I'm not sure. I've never heard of a criminal desk. I had some general questions. I think she put me on hold and then transferred me. Did she do a cold call or did she inform you?
I have no idea what's going on, sir.
Okay, I don't think there's anything going on. Just some questions. Is that okay?
Okay. Yeah,
Excellent.
what can I help you with?
Are you familiar with this? I've heard it's called a Section 810 application.
An 810 is a criminal peace bond under the criminal code. That's usually has to do with a fear of threat or injury from one person to another.
Okay. It's all very confusing. I just wanted to verify the steps, like the procedures, since it's your guys' procedures. Can you tell me, am I hearing this right from the internet? The internet says the first step is a sworn application. Does that make sense?
So maybe what I'll do is I'll tell you what I know of the system, because what an 810 peace bond is it's someone typically goes to the police and tells them that they have a fear of some sort. And the police then gather information and send it to the Crown Prosecutor's office. The Crown Prosecutor office then does their due diligence to see if there is enough to move forward with what they call swearing a common law peace bond. Once that has happened, if Crown does see that there is enough to proceed with the peace bond, they send it to the courts, which is where you're calling now, and we'll swear it. We'll hear circumstances, and then we'll swear it, and usually you've been served, the person would be served with an undertaking or an application from or an appearance notice from the police that telling them that they have a court date.
Okay. So thank you for telling me.
It's different in every province, so you have to be careful with what you're looking at on the internet.
That's why I'm doing, I think they call it due diligence. So let me just run by what the internet says, and you can tell me how wrong it is.
Okay.
So it says the first step is a sworn application. The second step, they say, is a judicial review. Third step is a summons is issued. And then the fourth, they say an appearance or reconnaissance. Does that sound correct or no?
No.
Please
No.
tell me where
I
the
think
internet's
they've got their
falling.
words mumble jumbled.
Okay, I'm listening.
From what it sounds like the internet is talking about is that they're talking about once the peace bond has been approved by Crown Counsel and the file has moved forward into the court process, what happens is the person would come, they would get in front of a judge, and they would have a hearing or a trial of some sort to see if there is a likelihood that that there is a potential threat to the victim. We'll just call them a victim at this point, or the complainant. And if the judge does believe that there is any risk to that complainant, then they'll put them on what's called a recognizance of allegations, or it's also commonly known as a peace bond.
Okay, so a Section 810, thank you for your explanation. Just some clarification, just to make sure that I got it all straightened out. So it's called an 810 application. Does that mean an application is filed?
So it's not called an 810 application, it's called an 810 allegation.
Is there a difference?
Well, an application application is somebody saying, like for us, an application would be something similar to, I don't know, for example, like if a lawyer needs to get off record, they file an application to do that, whereas an allegation is something that someone has done against, so someone has alleged that this person has hurt them, or they have fear that this person has hurt them.
Okay. So what is the section CCC 810-1A? What is that?
That is probably what gives the authority. So an 810 sub 1 is an information that may be laid before a justice or by or on behalf of a person who fears or on reasonable grounds that another person will, and then sub A is cause personal injury to them or their intimate partner or child.
Are you
or will damage their property.
Okay, are you describing a sworn application, or what is it that you're describing? I'm just still having a disconnect.
So I think your disconnect is you keep thinking application, whereas it's actually called an information. It's two different things.
Okay. And who is required to file this information?
So an information is processed and created by the Crown Prosecutor's Office of BC Public Prosecutions. They create information based on what they get relayed from the RCMP.
Okay. So, an 810, that's not criminal from what the internet says.
That's correct. Like, it wouldn't show up on your criminal, like a criminal records check.
Okay, so when it shows up on so it shouldn't show up on CSO, as you're saying.
Honestly, I can't comment on court services online. It's not it's a absurdity of us, but it's handled by a completely different department. As far as I know, as long as it has an access level of 1, which is just a generic, anybody can access the file, it will show up on court services online, which I don't believe these have any bans associated to them, so the access levels wouldn't change. So they should be available on court services online.
Okay, that makes sense. I've got a little bit of idea what you're talking about. So now the question is, do you know where the procedures are for an 810-1A to begin?
Well, I mean, if you look in the criminal code, that's where, like, they get, the Crown and everybody gets their information from their guidance on how, like, what to do with an 810. There's also, if you Google, like, Peace Bond BC, there's a page that comes up that talks about peace bonds, and it's very light. There's not much to it. But it sort of gives a little bit of overview on what it is. But everything that, like, the court looks at is through the 810, through the criminal code.
Okay, so do you guys refer to the CSO or to determine what the current state of a file would be?
No, so we have our own system that's like more in depth. So what's on court services online is just a very bare minimum bones of what people can view through the public, but the courts have their own in-depth system.
Okay. So can you tell me, is there needing to be a sworn application or anything at all? Like, what begins this section 810? What is the very first requirement? That's all I need to know.
Sworn information has to be presented to the court
by a somebody that is
by the Crown Prosecutor.
So who would be alleging the fear?
Usually the complainant would allege that to the RCMP. So, like, just for example, say there is a man and a woman live together. The woman is fearful that the man might hit her. She would go to the RCMP and say that she has some fear that this is what's happening. The RCMP will look up that information, take that to the Crown Counsel. The Crown Counsel would prepare the information.
Okay, and is any of that sworn? Like, that sounds to me like the process of swearing in something.
So it doesn't get sworn until it comes into the court, where it goes in front of a justice of the peace, and they listen to a court liaison officer from the RCMP to hear the information that will go before the court to ensure that there is proper process. And that's a whole other conversation.
Okay, that's the judicial review. Does that sound right?
I mean, I wouldn't call it a judicial review, but I guess in I wouldn't call it a judicial review because the JP is only looking for certain things. I would consider it more a judicial review when the judge actually hears the meat and bones of the information.
Right, by the complainant.
But I feel like they might be using judicial review in the wrong term, but I can see how that sort of is I can see how that would kind of coincide with what I'm talking about.
Right, and that court hearing there is if the judge or the JP is going to determine that that it's worthy of looking into or moving forward, then there would be like a summons issued. I'm just trying to figure out how someone would know that there's a court date to appear for, right?
So typically what would happen is the RCMP have already been involved and they would issue, usually an undertaking is the common thing that would happen, but there can also be a summons issue or a warrant could be issued.
Well, okay.
There's multiple different avenues on getting someone to court.
Okay, so like if somebody was to say that there's, fear and they bring this information to an officer and the officer takes that information to the JP, and the JP decides whether or not to issue, a court hearing, like a summons? Like, how could there be an undertaking from the officer if it begins with an application or in front of the judge?
Well, because it doesn't begin with an application. It begins with an information. And all that in Canada, all that in BC in specific, all that is needed is an RCMP to issue. They have the authority under whatever laws the RCMP have to issue undertakings for people that may or may not have committed a crime, as everybody is innocent until proven guilty. They have the authority to issue what we call an undertaking, which would have a court date on it, to come before a judge to deal with the matter.
Right, but like as you said before, that it needs to be seen by a JP in order to determine whether or not to move forward with a summons.
Yes, but the RCMP have the power to put conditions on people based on the information that they've gathered before it goes to the Crown Counsel for their.
So that's the sworn application. So the officer swears an application, which is the beginning process for.
So the officers don't swear any applications. There's no applications. It's just information gathering. They would do an investigation, and they would give all of their notes to the Crown Counsel, who then prepare the information, application.
Okay, so the investigation. What starts the investigation into an 810?
Someone making a complaint against a person.
Okay, perfect. And that complaint, is that something that will be documented? I would assume.
Correct.
Okay,
yes.
And is that complaint sworn in?
It's just given as the JPs receive what we call a report to Crown Counsel, and it gives the basically an overview of what has transpired to lead them to that point.
So that's a yes then, right? Because the officer's going to sign that.
Yeah.
Right? He's going to, So it is correct. Yeah. There's a sworn application, and then there's a judicial review, and then a summons. So why would an officer then fill out a promise to appear on something that hasn't been sworn in, or a judicial review is commenced for a summons? Does that adding up now?
You would have to ask the RCMP how they have the power to do that, because I don't know. I just know that the RCMP has the power to do that. It's granted in our legislation that they're able to do that.
Right. So again, it seems like there needed to be a judicial review. So are you saying that the officers have the authority to bypass judicial review?
No, they don't have the authority to bypass a judicial review. They have the authority that if there is someone has fear, be it whatever it may look like, they can issue a document that tells a person that they need to come to court, and it may have conditions on it, and that all that information gets put in front of a justice of the peace, and they then decide, yes, it's good to go, it goes into court, or they say no, and then the undertaking is canceled, or whatever it may be that happens if it's not right.
Okay. Can I, last thing, because I want to get off the phone, it may take so long. Thank you for being patient. Can you do your best to just verify whether the beginning step of an 810 is an application or not? Can you just
No.
Okay,
No.
well, hold on. You say no, but how do we verify that? Because you're saying there needs to be a sworn application. There needs to be somebody reporting fear, and then the officer is going to relay the report of fear, and then that is going to be heard by a JP, which is the judicial review, and then based on that review, then a summons to hear it and move forward in the trial.
So no, what I'm telling you is that a complainant makes a complaint to the RCMP. They gather it all up. It goes in a report to the Crown Counsel, who then reviews it, decides that yes, there's enough information in front of them to lay charges against somebody. Then that information, not application, information goes to a justice of the peace to confirm all of the I's are dotted and the T's are crossed to get it in front of the judge.
Okay. So yeah, because I just, I've been just observing the CSO there and trying to make sense of it. If I was to just, I'm observing a file number.
Okay.
File number 45248.
Okay.
Just reviewing it for procedural correctness.
Okay. There is a warrant outstanding. I don't know if you know who this person is, but there is a warrant outstanding for their arrest. So
can you
they may
provide
want to get that dealt with.
Can you provide the JP that signed on this?
I can give you the last name was Miss Campbell on behalf of the judicial case manager, Miss Cole.
Okay.
So Miss Cole was the one that issued the warrant.
Right, and is that based off of any information?
Yes, it looks like the party was served with an undertaking from the police on September 24th, and they did not attend court on October 8th. And so a warrant was issued for failure to attend. And
is that from a summons or for something else?
It's an undertaking. It's a police-issued undertaking, which it's a valid document under the criminal code, and it has a date that you must attend court at.
So is there a charge, are you saying? There was a charge on that date?
Well, there's the 810 allegation information that's before the court.
And when was that sworn in?
The 810 allegation was sworn in August 3rd, 2023.
Okay, and who swore it in?
It was Justice of the Peace Clements.
Oh, okay, and so that's who was alleging fear?
That's not who was alleging fear. That was who swore the information. That's the Justice of the Peace. It looks like, according to the information, a Charles Damon was the one that made the initial complaint.
So, are you able to see any other information as to when the complainant filled out a Section 810?
Nope. That stuff all sits with the Crown. It's part of the disclosure that the Crown provides to the defendant.
Okay. So you mentioned that there was this. I do not even know what that means. This warrant. So that there's somebody heard the sworn in information, and based off that, did they summon somebody to come to court and they didn't come? How did somebody get notified that there was court?
Back in August, hold on, let me get my dates right. June, looks like June 2nd of 2023, there was an undertaking served with a court date of August 8th. That the defendant didn't show up on the 8th. They failed to attend as per that undertaking. So
okay,
then,
just for that undertaking, just sorry to cut you off, but just for that undertaking, can you tell me what the undertaking was for?
It was initially for uttering threats.
Oh, okay. So when you say initially, does that mean that there was some sort of alteration?
So typically what happens is you know how I was telling you that the police have the authority to issue undertakings based on what they see in front of them. So there was obviously some sort of altercation of some sort, I mean, allegedly, and this person was held by the police or arrested by the police for uttering threats. When they sent their reports up to the Crown Council said that there wasn't enough to charge under that section of the criminal code, so the uttering threat section, and the Crown decided to bring it down to the 810 peace bond allegation as opposed to the criminal charge that would have been sworn.
Okay, so in other words, whomever signed something, I guess is what you're indicating, they signed for something that was changed?
Correct.
Okay, was there any updated acknowledgement of this change to expect an appearance?
There doesn't need to be on that. I mean, and this is starting to get into legal advice, so I don't know how far I can go with you into this because it's starting to get above my pay grade. I'm not a lawyer. I don't know.
I wouldn't hold you to it. I'm not holding you to it. Not holding you to it. I'm just trying to get more than what the website says.
Yeah, so basically and again, I don't know exactly how it works, so please don't take me for word, but my understanding is that when the police submit all of their documents, the Crown has the authority to change the charges that come before them. They can either add them or just get rid of them altogether. In this particular case, the allegation is actually like a lesser charge. So the uttering threats is an actual criminal offense that if someone was found guilty, it would show up on their criminal record check, whereas the allegation wouldn't be. So the Crown did bring it down to the 810 peace bond, and then when they submitted that information for the justice to swear, they would explain why they went from uttering threats down to the 810 allegation.
Okay. So you're saying that they arrested someone under the threat of arrest for uttering threats, but then that was never laid, or was that laid and then altered?
So it wasn't technically laid. It was presented to the Crown Council as the RCMP said we arrested them based on the information we have. And I'm assuming they were arrested. Sometimes they're not arrested. The police just, I don't know exactly what happened in the background with the RCMP. But if the person was arrested for, they say, the RCMP say, we found this guy, he was, screaming bloody murder, whatever, I don't know, at somebody, so we think that you should charge them with uttering threats. Here's our information, Crown, we think you should charge them with uttering threats. Crown then looks at it, goes, yeah, no, it's not, we're not going to meet the threshold that Crown has to meet, which is the innocent until proven guilty, and we aren't able, we don't think that that this would move forward in court, but we do think that this person has some fear potentially of this defendant, so we are going to move forward with the peace bond.
Okay, for sure. And do you see anything on file there notifying a party that there's a peace bond hearing?
The only thing I can see is that once it was sworn, when the party didn't attend on the August 8th date and the warrant was issued, that then shows that it was changed to an 810 peace bond just in paper. I don't think there's anything official it's just they didn't swear it as an uttering threats. They swore it as an 810. And again, this is probably all in the disclosure that gets sent from Crown, so I don't know anything about it.
Okay, so did the JC issue the warrant on uttering or for an 810?
810. Because the uttering threats never moved forward into the court system.
Okay, so was the date for the hearing the same as the 810 as it was the uttering?
Correct, because they don't know, they don't always have, if it's someone with no fixed address, they aren't able to reserve them, right, if they don't know where they are, so they just keep the same dates.
Okay, and you said it was the date of appearance that it was altered?
Well, the day that I can't speak to when Crown decided that they weren't going to move forward with uttering threat charges, but it came down to the courts as a peace bond.
Right, like there was a court date set And then there was a warrant issued, but the court date was set for uttering threats, but the warrant was issued on an 8/10. Does that sound right?
Correct, but the person should have come to court based on the uttering threats, and they didn't.
Okay. So then the only thing they didn't show up was for an uttering threats, but that charge doesn't seem to exist.
No, because it was brought down to the 810 allegation.
Okay, so you're saying that the JP issued a warrant based on an application of uttering threats that was never entered?
Sorry, no, the judicial case manager issued a warrant based on the fact that the party didn't attend based on, they failed to appear to court as directed by a peace officer, which is what was on the undertaking, which was the uttering threats.
Yeah,
But
that never happened though. That doesn't seem like you're saying that the uttering threats thing was never actually filed. So how did they fail to appear for something that never happened?
Because it did happen. Crown just lowered the charges.
Is there an agreement about that? Like, how does
They don't need an agreement.
Oh,
They don't need an agreement.
oh.
I think you need to get some legal advice.
No.
From
Hey,
someone
no. That's
I don't
okay.
know if you're a representative, because
No. Just an observer. I just wanted to let you know I'm just observing the public files, and I figured this would be a great example.
That's fine.
Yeah. Yeah. See, like that's the whole thing. Is it sounds like you're not completely sure, and we're going over what knowledge you have, and you've been great.
Yeah.
Do you know somebody that can go above and beyond what we've spoken of? And I appreciate the effort.
Is that you've got three different policies and three different areas, right? So the courts, I know the court piece of it. If you want to know what happens from the minute it was sworn up until the person is dealt with in court in front of a judge, I can tell you that. Anything before that goes to Crown and the RCMP. I can't answer their questions because I don't know. I don't know their policies. I don't know what their files look like. I only know the court system.
For sure. Okay, so you could tell me that it was sworn in on uttering threats, which never actually was laid before the court, which means that there was no.
Yeah, I can tell you the RCMP looked at it and thought that it should have been uttering threats. What happened in the background with the Crown is a question for the Crown. When it arrived at the court registry, it was sworn as a peace bond.
Okay, can you tell me who swore the peace bond?
Yeah, I told you it was JP Clements.
Okay, and then the officer that brought that to the court?
I don't know.
Oh,
You have to go through Crown. I don't know that information.
They don't put actually.
I can tell you.
Okay.
Well, they have court liaison officer, so I can tell you that the court liaison officer that swore it was, bear with me a second, Gary Toll, Towle.
So Gary Toll brought that to the Crown, and that's how it got to you.
Correct.
Okay. So Gary Toll, that's the one making the claims, right?
Well, so he works for the RCMP. So he acts as their liaison with the court registry. I don't know if he was the one that told, he wasn't the investigating officer. He's
Right.
acting as
Right. Okay. So does that mean he takes and bears all the liability for the information sworn into the court?
Couldn't tell you that.
Okay. So when you guys receive files, you don't know where the liability is standing?
No.
Okay, but the court makes determinations on liability.
The court might, the judges might, but I don't think they do liability, because I would assume the RCMP has got some sort of protection. I couldn't tell you what that would be, but I don't think the individual would be liable.
Okay.
But I don't know.
So there's a peace bond with the court. Can you tell me what the number is on the bond?
The file number?
No, the bond number. That way we have something that's direct.
We don't have bonds. I don't know what you're talking about.
Well, it's a peace bond, right? I thought.
It's just a name. It's just the name of a document.
Yeah.
It's not an actual bond. At this point in time, it's not there's no money or anything attached to it.
So if there is a bond or there is not a peace bond is what I'm trying to get at.
Well,
okay, the peace bond is just the name of the document. So if you
Yeah.
ever get to the point where a peace bond is issued, sometimes they'll ask you to put money down. Typically, they don't. But a peace bond is just a name.
Okay, so is there an actual peace bond on that file number or not?
Well, no, because the peace bond is what happens once the person's been found guilty or not guilty, basically. So this hasn't happened. Nothing's happened on the file because it's outstanding.
So why is there 2 warrants?
Because the person hasn't appeared at court to speak to the judge.
Has there been any summons for them to know to appear?
Yes, there's been 2 undertakings that were both issued that were found good service. They've been served on the individual, and that individual did not come as per the undertaking.
So the JP actually issued the undertaking.
No, not the JP. So the JP issues the warrants, and the police, when they go under the criminal code, they can release on an undertaking. And that's what they did.
Okay. All right. I think we ran the boat dry. Anything else that stands out? That am I making sense so far? And it got some good questions, or do you think there's somebody I can talk to that could clear this up?
I mean, I don't know exactly who could clear it up for you, but Crown might be an option. Also, getting a lawyer for whoever, if you're looking into more in-depth questions, it might be worth it to see if you can get a half an hour of a lawyer's time, because they are much more in-depth. They learn about the code, right? So they know.
Oh, well, yeah, see, that's the thing is that I'm just looking at who's holding the file, because that's the liable party, and I think it's registered with the court. Is this file a court file, or an RCMP, or a Crown file?
It's all three. All three. It starts with a police file, it goes to Crown, who assigns it a file number, and then the courts are the holders of the file.
Okay, so I'm talking to the courts, and you guys are holding the file, so you have all the information, is that correct? Okay, so when I ask
we only have the information that is given at the time of swearing. We don't have any of the background information. That's all held by Crown Counsel until trial.
Right. So what you have that's sworn in that's essentially the entire file, is that correct?
No, because all we get is just the information, and then we do it verbally over the phone with the court liaison officer, and we only get the bare basics, just enough to get the file in front of a judge. Everything else then happens that comes for trial. Okay.
Can you see on that file it says cause? I've been led to believe that it should say application. Is that incorrect?
No, I don't know what that is, sorry.
Okay, so where it says cause on that file there, is there, it says cause. Have you ever seen it say application?
I don't believe so.
Is there an option for there to be an application filed for an 810 or just cause?
As far as I know, it's just whatever comes through the court system. So if it says cause, it's cause.
What would the cause be for a fear? What would cause fear?
Honestly, sir, I'm not sure I can help you at this point.
Okay.
I don't know the answers to the questions that you're looking for.
No, that's fair. I can't get blood from a stone. You're not giving me any other resource, so I'm trying to just use the resources available, but you've given me information. No, I'll be honest with you. They direct me to you. They actually say that you're holding the file and that you have all the answers. So that's why I'm in a bit of a stalemate, and I'm hesitant to get off the phone. Is that fair?
Well, fair enough. I'm sorry, sir, but I have to go. I have other matters I have to deal with, and I'm sorry I've been on the phone with you for half an hour.
Are you able to flag? Are you able to flag this for some sort of? I'm just trying to get some. It seems to me like this, and I got a few other ones, but this seems like something that requires some basic answers. Should I call another day?
Well, you know what? I can pass you off to my manager if you like, but I suspect they're going to have the exact same answers I have for you.
Hey, no worries. I'm not going to pretend that we can predict the future. So I appreciate your time. It's not in vain, and I'm sorry that it took so long.
No problem. Would you like me to transfer you to my manager?
Absolutely, that'd be wonderful.
Okay, just a moment, please, sir.
Appreciate it.
Should we answer.
Court Services, Rebecca speaking.
Hi, did you say Rebecca?
Yes,
How are you today, Rebecca?
I'm actually not feeling very well,
Oh no.
but I'm here, so.
Well, that's what counts. I just have some simple questions. I'm just looking at the logistics of it. It's nothing related.
Okay.
It just, I'm trying to understand the process, which most people don't do. And it's related to what your computer system calls an 810. I think it's called an 810 application. Does that make sense?
No.
Okay,
Well,
eight,
I'm sorry,
CC 8101A.
Okay.
And I'm just looking at what information you can, kind of fill me in on as the process. I'm just trying to do due diligence.
Okay, and I understand all that, sir, but you were transferred to me because you spent 35 minutes on the phone with my criminal registry clerk who explained all this to you. So, and then you asked to speak to a manager, and that's what you've done. Are you looking for further information?
She actually was only able to give in a personal capacity what she believes was the process, but she wasn't able to. She did really well, but it kind of was a suggestion that I speak to yourself there just to get some verification on a few things that we weren't sure about. She said as far as she knew and from what she's been led to believe but I was just looking for the procedural correctness relating to this 810.1a that your system seems to use.
Okay, can you hang on just one moment? Just one moment.
Okay. It's almost impossible not to use I statements.
So who cares if it takes 35 minutes or 3 hours?
I was transferred to her. I didn't ask to be.
But she wants to go home. That's why she wants to go home.
Yeah. Well, let's sit you in a cage and then see if you want to go home.
Yeah.
Perspective.
Yeah.
Either you're infinitely big or you're that big.
Yeah.
Trying to be infinitely big.
Yeah.
One looks better than the other.
My phone heats up in the sun, right?
Yeah, you're good.
Like right now, right?
Yeah.
Chunky monkey.
Daughters, all right. So she's putting me on hold because then she's going to talk to the other girl to figure out exactly what was said.
Yeah.
She's going to find out that, she didn't have any validity to what she said. She was conveying her understanding or what she's heard or what she's seen or what she was told.
Hi. Okay.
You guys get it figured out?
I did speak to the registry clerk, and I believe this has something to do with that you were originally, the police charged you with uttering threats.
One second.
The Crown Counsel.
1 second. You're saying, are you saying that charged me? Is that what you're saying? Because I'm just observed a file and had some questions about it. So there's not necessarily a connection. Yeah.
Okay, so you observed a file?
Yeah, that's what I believe the CSO is there for, right?
What do you? Okay, so you looked on CSO, you just found some random file, and now you want to know all of these procedural questions about it?
Well, there's a
that?
public accessible domain, and when using that domain, and looking at just trying to get a bearing as to how the domain is set up for those using the interface, And so these are just clarifying questions in order to try to navigate.
Okay, so you're talking about court services online?
Well, that's where I guess the file number comes from.
Okay, so just let me see if I can follow this along. So you have this file, and you want to know the procedure for it, of what it means, for the fact that this person was charged by the police. The Crown Counsel said, we don't believe it falls under that. We're going to lower the charge to a peace bond. That person then doesn't show up for court, and a warrant is issued for their arrest.
One alteration, it's actually a file that you guys have, and that I observed, and now I'm just questioning about the procedure related to what you guys call an 810-1A. So not necessarily is it to do with that file, but it's brought to attention this 810-1A, and I just wanted to know what the process is. The online, like the internet, is kind of giving some information, and I don't believe everything on there. I like to talk to somebody that's familiar, like maybe potentially yourself here. And I found that it's telling me that the first step is a sworn application. And it seemed like me and the other lady there had said that, yeah, that's correct. The sworn application is first. And then there's going to be a step 2, and I just wanted to know what is the procedure from 1 through, I guess the end.
Okay, so my understanding was that was explained to you by my registry clerk.
Oh yeah, she transferred me to you because she just transferred me to you because she wasn't sure. That's all.
Okay, so my role in the registry is actually just to kind of oversee registry operations. If you want to know an actual operational question, your best bet is to speak to the registry, like somebody who works at the criminal desk.
That was who I spoke to. That's who I spoke to was at the criminal desk. Yeah, she transferred me to you.
Yeah, she transferred you to me because you asked to speak to somebody higher.
No, she transferred me because I was still looking to get an answer she couldn't answer, and I think she had made the determination that someone higher may be holding these answers.
Okay, well, I'm sorry to tell you that I am not holding the answers.
No problem. Maybe she should be made aware of that. Maybe just transfer me back so that this isn't in vain, because we can't necessarily spend this much time and not get anywhere, right? And still have confusion over something that seems simple, like an application or a peace bond, right?
Okay. Okay. Well, I will put your phone call through.
Appreciate it. So you're telling me she's the one with the answers, so to not give up. She's
No. No. See, the thing about the registry, sir, is that the courts are only involved on the last step of this process. It starts with the RCMP, it goes through Crown Counsel, and then it ends up in the court system. So if you're asking for a process, how it starts, then we're not the people to answer that question.
So an 810 application does not begin with an application for a peace bond?
Just one moment.
Thank you. Every time I do this, I get to the bottom of it.
The criminal code?
I'm just relaying what I seen there, which is an 810 application 1A.
Okay, so application. Cognizance after codification.
So a section 810, I think, could be one of the codification words.
Section 110A.
810, section 810 1A. 810, section 810 1A.
See, I'm getting the section 810.01, but
Yeah, that could be correct. Yeah, I've
Did you
seen
look
that,
at-
and then
did you-
I've seen that before
did you
too.
look under the Criminal Code of Canada? Like, is that where you're getting the information? Is from the Criminal Code?
CSO actually. Yeah, it's the CSO that I was looking at. And it says CCC section 810.
Okay.
And then, it gets confusing because it's not a criminal charge, but it's under the criminal code. So that's why, obviously, it takes some phone calls to figure this out.
Okay, well, uttering threats is a criminal charge.
Yeah. Okay. Yeah. I've heard that that's under 264 or something. But I don't see what that has to do with section 810. Those are two different numbers, right? What made you say 264? Just curious.
I didn't say 264.
You said uttering threats,
You
which
said
is 264.
I said uttering threats is a criminal offense.
Yeah. Who
You said
brought
it's
up
not
that?
act-
Who brought up uttering threats though?
That's the file you're looking at.
I'm looking at the okay. So
person.
you're looking at a file that says uttering threats. Can you tell me the charge codification?
No. The conversation I had with the criminal clerk was that you said that you were looking at a file where somebody was charged by the RCMP for uttering threats.
No.
And then it was pled down to a peace bond by Crown Counsel.
Is that what she said? Yeah, no, I only talked about a section 810. That's been my consistent question from the beginning because nowhere at all on the CSO is the uttering threats ever mentioned. So I wouldn't have necessarily brought that up. I don't see any record of that.
Okay, so 810, an information may be laid on behalf of any person who fears on reasonable grounds that another person will cause personal injury to them or their intimate partner or child or will damage the property. Okay. 810. Sorry, I'm just looking at the Criminal Code of Canada.
That's okay. Thank you for doing this, even though you're not feeling well.
Used to keep the peace. 810.1a. Okay, so 810.1a is a peace bond that is laid because, on behalf of any person who fears on reasonable grounds that another person will cause personal injury to them or to their intimate partner or child or will damage their property. That is what an 810.1a is in the Criminal Code of Canada. Yes.
Perfect. Now can we get the first procedure requirement?
Says a justice who receives an information under subsection 1 shall cause the parties to appear before him or before summary commission court having jurisdiction in the same territorial division.
Okay, so that's a fancy way of saying a summons would be issued. Is that correct?
Yes.
Perfect. Okay, so can we say that the first procedural step is an application, or somebody is going to swear in some information before a JP, and then that JP is going to then summon somebody, and if they don't appear, then a warrant is issued? Perfect. Okay. So, would you say that it's important that there was some sort of a sworn application and a summons that would be on file in order for this to have jurisdiction?
Sir, I'm not exactly sure where your questions are going.
Okay,
Like, if
yeah,
you
yeah,
wanna
for
know-
sure. Okay, let me just put it simply. It
If you-
sounds to me an application is
No.
filled out. Yeah, okay.
So if you're asking, like, the process of how, the RCMP lay the charge, they send the charge to the Crown Counsel. The Crown Counsel reviews the facts, decides it doesn't meet the threshold for uttering threats, but kind of a little on the side. So they're going to issue a peace bond. Okay, that process, the courts have nothing to do with. If you have questions about that process, you would need to talk to Crown Counsel.
Oh, okay. Are you talking that the othering threats, something was signed for that, and then they decided to not go through with that, and so they have a 810 application or hearing or information sworn in? Then the JP is going to hear that and then issue a summons. So you're saying that a summons would be required before a warrant could be issued?
So the RCMP lay the charge.
It's
They send it to Crown Counsel. Crown Counsel decides that they're not. Okay.
yeah, you caught it. You see what I'm saying now. Yeah, they needed to make a new file number and fill out a application or a sworn information from the one fearing. And then there needed to be a hearing and then a summons before anything like a warrant.
Are you writing a newspaper article or something? Like I'm not sure exactly what.
The last thing.
We don't usually get this many questions from someone unless they're.
Yeah, for sure.
Their file.
Yeah, fair enough. Here, let me just put it this way. The last thing I want to do is publicize this. If anything, it'd make more sense to just have it looked at, and if there's obviously a mistake, it could just, whatever needs to be done. I don't believe there's any information there showing that there was a JP that actually summoned for a hearing. But yet there's a JP that seems to have issued a warrant or even two. So I'll just leave that with you in good faith that this file here is obviously something needs to be corrected.
What's the file number?
You don't have it there? Well, I mean the website here is indicating 45248. That's just what the CSO is indicating on the public forum here.
Okay, 45248. Let's see what we got here. I'm just going to look at the document. So it looks like an undertaking was done on June 2nd. Undertaking was issued on June 2nd. It was 10 court on August 8th. Okay, so yeah. So undertaking was issued saying after 10 court on August 8th. They didn't show up. Warrant of arrest was issued. then an undertaking was issued on September 24th saying peace bond. You must attend court on October 8th, 2024. They didn't show up, and a warrant of arrest was issued. So the person would have been notified of both those undertakings, and both those undertakings had a date of which they were supposed to show up.
Yeah, I'm glad that we went over what an 810-1A's procedure is, which indicated that there was information that would be sworn in, and then there would be a JP that would then summons the party. And so I'm just looking at, is there a summons at all issued?
Well, the undertaking was done by the police, and the date would have been provided, that a copy of the undertaking would have been provided to the party, and on that undertaking is their court date.
Yeah, we just went over that there had to be a sworn application or sworn information from a party fearing, and I just don't see how that can be done by a PTA or an undertaking.
I'm sorry, I can't answer that question.
Am I wrong to say that, or are you saying that the procedure of an 810 is a promise to appear?
An undertaking is something that is issued to someone to say, this is what you're going to be charged with. This is when you have to show up in court.
That's for criminal, though. But this isn't criminal. This isn't a criminal charge.
Uttering threats is a criminal charge.
That's right. Do you see on that file number anything stating uttering threats? Please let me know if you do.
Yeah, it's on the first undertaking.
You have under that file number. You have on the CSO. You can see that.
Yes.
So if I search that file number, why does the public not get to see? Is it this information?
Because you have to pay.
So you're telling me that the uttering threats is not visible, but the peace bond is?
I have no idea how it works on your end. Just let me see what I can find out.
Okay, thank you. Yeah, because it seems to me that you have, there's information that you're relaying that is not publicly available, so it's very hard for one to be expecting.
Well, that's because the information that I have is obviously more, there's more to the information that I have than there is to the information that you're entitled to.
I don't know who would be entitled necessarily, but is it not the information's provided in order for one to be able to, I mean, if they're not aware of something and the websites to be aware of something, if you say that there's some sort of uttering threats, was there charges laid for uttering threats or not?
Why is that telling me that? It's not true. I did. Ugh. Okay.
Thank you. I appreciate it.
S.810. Yeah. Charges. Fear of injury person. Okay. The undertaking was done by the RCMP under Section 264.1-1-A. That was uttering threats. That was done by the RCMP. They sent that to the Crown Council. The Crown Council said, we don't believe it meets the threshold. We're going to put it down to issuing a peace bond. That's why it shows a peace bond on Court Services Online.
Okay, so is it safe to say that there is no uttering threats, and for this file is not connected to any uttering threats, is it?
I'm not sure exactly what it is you want me to say, sir.
Oh no,
Like
I'm just trying to make
I've told
it
you how
clear,
the file started.
like you're saying that there
No, I told
was
you how the file started.
like for that court date.
Started.
Like for that court date, was the court date for uttering threats, or was the court date for Section 810 for the first warrant?
No, the first warrant was for uttering threats. It was Section 264.
Okay, so yeah, on CSO it actually says Section 810. So what's going on here?
Well, no. If you want to know every document that's on the file, just let me see. When did we even do that? Participants, charges, appearances.
Yeah, it's got the same file number. That doesn't make any sense. There should have been a new file number for this to be somewhat coherent.
I'm too sorry. Yeah. Okay. No, it was started as an uttering threats. It was on the undertaking. Undertaking would have been given to the accused to say that this is what you're being charged with. When you come to court on August 8th, they didn't come to court on August 8th. The warrant was issued. I believe, without looking at the file, that meant that they turned themselves in, or the warrant wouldn't have been canceled.
Yeah, you should look. You should look at the file. You might find it to be different.
Okay, well, sir, I believe that I've answered all the questions. I'm just not sure exactly what it is that you're looking for from me today.
Okay. I'll summarize it. You're indicating that if I was to go onto CSO and search that file number, that there should be something that says uttering threats. This does not exist on the CSO, and I wanted to understand why the two warrants that show up for this file number, neither of them are connected to an uttering threats, but you're indicating that the first one is related to uttering threats. Is there some sort of lost in translation? Does this happen often?
If you have questions about Court Services Online and the information that is on Court Services Online, you need to talk to Court Services Online. All I can tell you what is showing in Justin, what is showing in our computer. That's all I can tell you.
Okay.
I don't know anything about the information that
last
is
question.
on Court Services Online.
Yeah, last question. So for the first warrant that was issued, can you tell me the date that was issued for uttering threats? That's all.
August 8th, 2023.
Okay, and the officer that swore in the claim of uttering threats?
I don't know. Is that August 8th? Purposes. North Couch and Duncan. Must not communicate. It doesn't have a name. It just says, doesn't have a name. It just says North Cowichan / Duncan RCMP.
Is that normal?
I'm sorry, sir. I can't answer that question. I don't look at very many undertakings.
Okay, fair enough. It does not appear to be a place for the officer to put their name. Okay, and then the JP that ruled on what court date and what was their name?
Warrant from arrest was signed by S. Farrow. Farrow.
Okay. And what date was that?
That was August 8th, 2023. It was issued after the accused did not show up for court.
Okay, and that's related to the uttering threats charge, which was sworn in on which date?
Sir, we're going in circles
I
here.
just wanted to make sure that you're saying what was the sworn in date?
We are literally going in circles here.
It was the last question. It was literally going to be my last question.
No. It was the last question 4 questions ago.
Yeah, just wanted clarification. We would have been done, I promise. So you're saying that the actual uttering threats allegedly happened on what date? Just verifying.
June 2nd of 2023.
Okay, I appreciate it. Thank you. I know I do appreciate it, and I know you're not feeling the greatest. You stuck in there. I know it's overtime. You're at the end of the day. I'll leave you with that. I promise you it wasn't in vain. I hope everyone gets the same service as this. And again, I might have some other questions about other files as I look into this to understand the computer. Thank you.
Okay.
Thank you. You have a great evening. Bye. To show her that I'm not fucking done, right? I'm gonna fucking...